back to another episode of ACA Cast with your host this week. My name is Alex Zito. ACA Cast is the official podcast of ACA International, the leading voice of the accounts receivable management industry. Before we start today's episode, this episode is for general references only and should not be used as legal advice. We're going to discuss soon-to-be law, robocall legislation called the TRACED Act. Joining with me today is Leah Dempsey, ACA's Vice President and Senior Counsel of Federal Advocacy. How's it going today, Leah?
Thanks, Alex. Going well, and I'm really pleased to be here at Hogan Lovells with Mark Brennan, who is the Global Lead Innovation Partner at Hogan Lovells and one of the TCPA experts. He is well known for his victories on the Telephone Consumer Protection Act and advises a number of clients throughout the country, including ACA, on some of these issues. So today we're talking about the TRACED Act, which is a piece of legislation that ACA has been engaged with Congress on really for almost a year at this point. We've seen several iterations of it and have appreciated the fact that Congress has been willing to consider some of our feedback and consider the impact of some of their original proposed legislation on the accounts receivable management industry. Just as background, you may recall that the TRACED Act, the original version, passed the Senate in May of this year. In July, it passed the House, both overwhelmingly through both chambers. The House and the Senate Commerce Committee and House Energy and Commerce Committee have been negotiating on a package that would incorporate both of these pieces of legislation really throughout the fall. We recently saw the passage of this new package through the House as of last week, and it's expected that it may be passing the Senate anytime soon. So just wanted to take a few minutes today to sit down with Mark, who has been advising a number of clients on some of these issues, and see what his thoughts are. So Mark, the legislation that passed ultimately looked very different from the original Bad Robocalls Act that we saw early in the 116th Congress. Can you talk a little bit about the progress that was made and some of the wins that industry may have benefited from as a result of some of those changes in the House bill?
Absolutely, Leah. And hi, everybody. Thank you very much to ACA for inviting me to participate today. Delighted to be here with everybody. Thank you, Leah, for the conversation. As you mentioned, the bill that passed the House was dramatically different from the original Bad Robocalls Act. Namely, it ended up being a bipartisan bill that was able to succeed in that chamber. Originally, the Bad Robocalls Act would have resuscitated some of the Obama-era FCC TCPA decisions, including the elements that the D.C. Circuit had struck down when ACA appealed it. The bill, as originally drafted, would have had a wildly overbroad approach to a number of challenging TCPA issues, and frankly would have been harmful to consumers and businesses alike. It also would have made the TCPA an even larger boon for the plaintiff's bar, creating all new paths for abusive litigation. But ultimately, the biggest issue was that it was highly partisan. And as many are aware, any highly partisan legislation has struggled in this Congress, where you have the Democratic Party in control of the House and the Republican Party in control of the Senate. So partisan laws have had trouble moving this year. And given the attention that had been placed on calling, texting, TCPA, and the so-named robocalling issues this year, there was an opportunity to work through a number of bipartisan elements, including on some of the key issues like auto dialer, reassigned numbers, call authentication, call blocking, and more. And so that's where the bill ultimately landed, with bipartisan vote in favor. And to be fair, the TRACED Act that had originally appeared in the Senate and passed the Senate earlier this year was also dramatically different from the legislation that's passing now, mainly that the House bill covered a variety of things that were not in the TRACED Act that passed earlier.
Thanks, Mark. I think those are important points for ACA members to be aware of. While the bill in its current version may not be the perfect piece of legislation, I think it's important to think about what it could have been if us and others didn't have a seat at the table in some of these discussions, because I think we could be in a much worse place where people were seeing even more frivolous TCPA litigation than they're seeing right now. So we appreciate that Congress worked closely with us to improve the bill. However, I think there probably are some aspects of it that are still concerning to ACA members. Do you have any thoughts on anything in the legislation that we may want to think about down the road that could potentially cause some problems for us?
Certainly. I mean, look, the legislation covers a lot of ground. It covers a lot of important issues that people care about, and it reflects the input of many different stakeholders. So the staffers involved and the members behind this legislation, it's a testament to their willingness to work and seek input on these issues. I think one of the challenges ultimately is that bill does not solve the toughest issues that consumers, companies, and other stakeholders face today under the TCPA. So it does kick the can a bit on some of the tough issues. For example, it does not clarify or settle the long-standing uncertainty about the meaning of the definition of automatic telephone dialing system. It also does not clarify or settle similar issues with the meaning of called party and what happens if you call somebody at a phone number for which you had obtained consent, and by the time you place the call, the number has been reassigned to a new subscriber. And several other issues that a number of parties, and again, speaking to not only parties that relate to businesses and parties who place calls, but other stakeholders in the ecosystem, including consumer advocates, have sought for further clarification. And that means that it's now up to the FCC and the courts to settle some of those issues, but it would have been nice to see Congress tackle those. The legislation also does not change one of the most challenging aspects of the TCPA, namely the statutory damages provision with no limitation or cap on the overall damages. And we've seen some eye-popping litigation numbers out there, and those abuses by the plaintiffs' bar really are harming good faith American businesses. So it would have been nice to see Congress tackle that and resolve some of those issues, but we did not see that appear in the bipartisan legislation.
Thanks, Mark. I think to ACA members, that's a really important point because, as you know, since our decision out of the DC Circuit, looking for clarity on the definition of auto dialer has really been an important aspect of our advocacy. And during times of the discussion that really occurred over a year, we were hopeful that Congress might be able to help us get some clarity from the FCC. However, it looks like ultimately this bill kind of, as you said, kicked the can down the road, and we're hopeful that the FCC realizes that there's still a mandate from the DC Circuit out there. There's still a number of courts throughout the country that are looking to them for more guidance on this, and just because Congress didn't include it in this specific piece of legislation, it doesn't mean it's not something that's extremely important to not just ACA members, but really millions of businesses throughout the country.
That's right. And, Congress had an opportunity, frankly, to help the FCC and resolve some of these issues, but it chose not to. So the pressure and the obligation remains with FCC to solve these issues. And as you mentioned, the open issues in pending proceedings at the agency on a number of TCPA items now will still need to be solved. It was also disappointing to see that Congress did not have anything to say in the legislation on timing for the FCC. The House bill would have put a clock on the FCC to wrap up some of these TCPA issues, and that's not appearing now in the final draft.
Another aspect of this bill is that it also directs a number of rulemakings and reports on things like call blocking and labeling. These are obviously issues that the FCC is already taking a look at. How do you think this changes, anything they're already working on? Does it change anything they're already working on? And if so, does it change the timing on any of those things?
Well, I mentioned a moment ago that the legislation does the FCC no favors. When you look at the final compromise bill from the reconciliation process, there are many different reports and rulemakings and other proceedings and working groups created by the bill that I think, frankly, are going to keep the FCC active on these issues. For example, it has to do an annual report on robocalling and spoofing. It has to consider further some of the shaken and stir call authentication requirements. It also has to do more on resolving some of the open call blocking processes. It has to publish best practices for call authentication, and on and on and on. The FCC is going to be very busy this year, and we should expect to have a number of notice and comment rulemakings and other proceedings and other areas where the agency is going to be requesting input. I don't expect that it will eliminate by any means the need for the agency to resolve the core TCPA issues. And I think what Congress is saying with this legislation is that they want the FCC to clarify. They had the opportunity in the bill to issue their own interpretations, and they didn't. So now it remains with the agency. Some of those proceedings are several years old, and it's time for the agency to act. So what's interesting to me is that all of these proceedings that are, and the reports that the FCC has to write under the new legislation don't focus on the already pending issues. So I read that to say that the FCC needs to continue on with its mission there and resolve that. And then it's all these other issues on top now that Congress has identified as other things the agency needs to also handle in the near future.
So it sounds like the FCC is going to have a pretty busy year in 2020, and I think it's going to be important for ACA to have a seat at the table for a lot of those conversations because, as we've discussed on other webinars and podcasts, this issue of call blocking and labeling is something that really has evolved over the last year. A lot of the original information that we saw from both Congress and the FCC really provided no recognition at all of legitimate callers. If you think back to the original TRACED Act, it didn't say much about legitimate callers and the need to unblock calls. Same with the FCC declaratory ruling that we saw earlier this summer. It originally didn't provide much recognition at all for the need for legitimate business calls and the need to have those unblocked. Over the course of time, we were able to, I think, make some dents in that thinking. And I think advocacy is really a process and not an event. And this really is a good example of that because what we saw out of the declaratory ruling in May, the original draft that we saw didn't say anything about legitimate callers, and we were able to work with the FCC to add at least some language acknowledging the need for unblocking calls. Same with this legislation. The final bill that we saw does talk about transparency and redress to callers. It also makes the point that callers should not be charged for unblocking calls. Over time, we're having somewhat of an effect on making them see the value of legitimate calls like those coming from the arm industry and other partners that we're working with in DC. But I guess, Mark, do you have any thoughts on that? And, have we made any progress and how far do we have to go as they move forward in things like shaken and stir?
The call blocking decision, the declaratory ruling from earlier this year, to me is really a testament to the value of giving the public an opportunity to weigh in on important issues. Many who are listening to the podcast may be familiar. The FCC now routinely puts out a draft of its key decisions 3 weeks before the items will be voted on by the commissioners. And then the public has 2 weeks to weigh in further before a 1-week quiet period at the agency. On this item, I work with a variety of stakeholders on these issues, and just my own reaction when I saw the draft, it really seemed like somebody at the commission gave an instruction to staff to say, do something about calls, do something about robocalls. We have to do something, but without any real clarity behind that, because the draft seemed very rushed, and it seemed really void of key details. And importantly, it looked like there had been such a focus on stopping illegal calls at the agency that they seemed to forget about the impact they were having on lawful calls. And as you remember, Leah, there was language in that declaratory ruling about blocking unwanted calls. There was really no definition of unwanted or what that meant or how it would be applied consistently. So there was just this opportunity for us to go in and talk about how different lawful communications and the need that consumers, well, the impact on consumers, the impact on businesses when, for example, calls are blocked and the consumer doesn't even know it's being blocked, or the impact to public safety if public safety communications are swept up in this. And really, it's many of the blocking apps out there are continuing to evolve. And when we look at the data, there's so many calls that are being mislabeled by those third-party apps. And I understand that no system is perfect in that way, but the error rates are astonishingly high. And there continues to be a need for further engagement on a variety of these issues. It's my sense that the advocacy throughout the year from all parties really had an impact in shaping the FCC's decision, the later rulemaking that they commenced on call authentication, and now this new legislation to ensure that there was valid consideration and due consideration given to lawful American companies looking to engage with consumers and provide the calls that consumers want and need.
So Mark, any other thoughts or insights on what the next few months might look like for actions both surrounding call blocking and labeling and TCPA? Any idea what the direction of the FCC might be?
I hope that the FCC moves promptly to start working through this pile of items from the legislation to continue to move through the backlog it has on TCPA. I think you'll see sooner rather than later the agency launch some of the rulemakings that are in the legislation and rulemakings and other proceedings. And so you'll see continued activity on the call authentication and call blocking proceedings. For example, the FCC has to adopt additional call blocking rules within a year of enactment of the law. There are also there are provisions to require the FCC to adopt rules that streamline the ways in which a private entity can share with the FCC information related to TCPA violations. So all of these things and others, I think you'll see them launch those proceedings quickly because they need to get them started in order to have a chance at meeting the deadlines in the legislation. You'll also see them commence some of the working groups and other things that tie into eventual reports that are required by the legislation. So I would expect that first quarter of the year is going to be very active on that. Then I think becomes a ripe opportunity for them to get into decision time on some of the TCPA backlog issues like auto dialer, reassign numbers, consent revocation, and other issues that everybody's been asking them to clarify for some time now. Then as we get into the later part of the year, that's when you will start to see them putting together some of the draft requirements in the rulemakings where there's a deadline. The election will certainly play into that as parties start to focus on the election and the campaigns. You just tend to see a number of items at the agencies get a little bit quieter that window. And so I think you're going to actually see about 12 months of activity condensed into 6 or 7. We're at the FCC. So timing-wise, look for a really busy first quarter and then sustained activity throughout. And now is definitely the window for the current chairman who had, before becoming chair, been vocal about where the agency needed to go on TCPA. This is the opportunity to get it right. So hopefully we'll see that.
I think you bring up an important point about the fact that it's an election year. Anytime that it's an election year, I think sometimes all bets are off the table and you never know how active agencies will be, knowing that political winds are often pulling or pushing things. One thing that I think may help with some of that is the fact that there is also a slight chance that the Supreme Court may be taking a look at some of these issues surrounding TCPA. Facebook has their petition there right now. Do you think ultimately that could play a role in any of this or be helpful in pushing the commission to act on any of this?
I think the court certainly has the potential to create an impact. Unfortunately, I see a number of potential paths, some of which are helpful and might provide additional guidance and perhaps helpful guidance. And then there are other ways where the court might address an issue and perhaps create even more confusion and complexity in this area of law. So we have to see which docket they end up with and see this through the oral arguments next year, but that will be another area to watch. And the timing of the decisions also will be important, especially as the FCC tries to sort through some of its obligations under the new legislation.
Well, thank you, Mark, so much for being with us here today. I think, the moral of the takeaway today is there's still a lot of work for us to do in DC on these issues. There's still much needed clarity in both the areas of TCPA and call blocking and labeling. But we appreciate the fact that this bill that passed is a lot better than what it could have been. Ultimately, I think it doesn't make our lives much worse. Originally, I think it probably would have. So we're happy with that, but we're going to keep working on this and looking forward to working with ACA members on this throughout 2020.
Thank you, Mark and Leah, for joining us in today's episode. For further development, stay tuned to ACA Daily for more information. You can subscribe to ACA Cast on iTunes or wherever you download your show so you'll never miss an episode. While you're at it, please review us on iTunes. Thank you for listening, and we'll see you next time on ACA Cast.